Right. Are you Dylan Harner appearing there from the jail?
Yes, sir.
All right. There are two cases here this morning involving Mr. Harner. Case number 23 CR 20, which is a case that is set for sentencing. And then there's a new indictment in case number 23 CR 108 for failure to appear. Now, this hearing is being conducted by Zoom. Mr. Harner's attorney, William Armentrout, is appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. And Mr. Armentrout, are you and your client both in agreement this matter can be conducted by Zoom rather than his appearing personally in the courtroom?
Yes, Your Honor.
And you're all right with that, Mr. Harner?
Yes, sir.
All right. Now, we'll deal with the new case first. This is a charge of failure to appear that was returned by the grand jury on June the 6th, and it alleges that on or about May 18, 2023 in Highland County, Ohio, Dylan Harner did recklessly fail to appear as required in Highland County Common Pleas Court case number 23 CR 0020 after having been released pursuant to ORC section 2937.29, and the release was in connection with the charge of commission of a felony in violation of section 2937.99 of the Higher Revised Code, and that's the charge of failure to appear, which is a 4th-degree felony. Now, I see that we have a proposed plea of guilty form here. Mr. Armentrout, you and your client have consulted upon this matter and negotiated this agreement as part of the proceeding this morning with the sentencing in the other case.
We have, Your Honor. I think it should be noted that I spoke with Dylan yesterday. I spoke with Dylan at length previously in the other case. He hasn't been right on the paper here, but he understands what it is. What I had filed for discovery, but the discovery of failure to appear is about 3 pages. And there was a prior hearing and he didn't show up for it, and that would be all that there is. I believe that he understands it and is prepared to go forward on that also.
All right. Is that the case, Mr. Harner?
Yes, sir.
All right. And I note that you did fill out your financial disclosure form for that case, and everything on this financial disclosure form is correct?
Yes, sir.
All right. Then court will appoint Mr. Armentrout to represent you in that matter as well. All right. So we'll address that case first. Well, let me go back up. In case number 23 CR 20, the defendant entered a plea of guilty to receiving stolen property and identity fraud, 2 4th-degree felonies. And Mr. King, have the victims of those offenses been notified of the time, place, and purpose of this hearing and their right to be heard? And
yes, they have, Your Honor. They've not been traced.
all right. All right. Ben, according to this, I ordered a pre-sentence report. Did you check and see if we have that report? All right. Now, Mr. Harner, I have and we'll go to 223 CR 108. That's the new charge, the failure to appear. And I'm going to hold up this plea agreement form. It has your name and case number and says you're pleading guilty to that charge. You recognize that form?
Yes, sir.
Okay. And on page 3, about a quarter of the way down the page, there's a sentence that reads, I enter this plea voluntarily. And is that your signature immediately below that sentence there?
Yes, sir.
And when did you sign this agreement, Mr. Harner?
The other day.
All right. When when you signed it, did you understand that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did Mr. Armentrout explain everything to you and go over it with you and answer any questions that you had?
Yes, sir.
And do you feel that you had enough time to fully consider this matter before making the agreement to sign this document?
Yes, sir.
And since it's been a couple of days since you signed it, is this still what you want to do?
Yes, sir.
And are you entering into this plea agreement voluntarily?
Yes, sir.
All right, now the agreement states, thank you, that you are going to plead guilty to the charge of failure to appear in violation of section 2937.29 or 99 of the Higher Revised Code, a fourth degree felony. States that you understand the penalty for that could be a minimum of 6 months in prison and a maximum of 18 months and a fine of $5,000. You understand that?
Yes, sir.
And you're facing the same sentence in the other case for the two fourth degree felonies there, 6 to 18 months. So if the maximum prison term is imposed in each case, in each offense consecutively, one after the other, it means it'd be a maximum of 54 months. Do you understand that?
Yes, sir.
And then there could be a maximum fine of $15,000. You understand that?
Yes, sir.
And I know that you have a charge you're facing in Claremont County. Are you facing any other felony charges anywhere else?
No.
All right. And are you on probation, community control, post-release control, or parole for a felony in any other county?
No.
All right. Now, if you are sentenced to prison in the Claremont County case, and the reason I know that is the judge down there had sent a letter and requested that you be allowed to go down there after today's hearing for that case. But in the event that you're sentenced to prison in Claremont County and this county, then whatever it is you're facing in Claremont County, I'm not sure what the charge is, but whatever it is, could, if you're sentenced to prison, could be ordered to be served consecutively to the sentence in these cases. Do you understand that?
Yes, sir.
All right. Now, under the law, Mr. Harner, if you're sentenced to prison, once you complete the prison term, the Adult Parole Authority could decide to exercise the option to put you under post-release control supervision for a period of up to 2 years. They don't have to, but they can, but it's up to them. If they decide to do that, you'll be supervised under the term set by the parole authority for a period of up to 2 years by a parole officer, and if they determine that you have not complied with those conditions, then they could return you to prison to make you serve an additional period of up to 9 months for a single violation, but there is a cap or limit of half of whatever prison term you serve for all violations. However, if you're convicted of a new felony while under post-release control in this case, then in addition to whatever sentence could be imposed in that case, that judge in that new case could also sentence you for committing the new felony while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
All right, now, this offense is not a mandatory prison offense, Mr. Harner, so it is possible that instead of going to prison, you could be put under what's called community control for a period of up to 5 years on a term set by the court. If during that period of time the probation department thought that you were not complying, they would have to file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison, on this case to 18 months and fine you $5,000 in addition to whatever sentence could be imposed in the other case. Do you understand that?
Yes, sir.
Right now, I read the charge to you just about 5 minutes ago, and you recall that.
Yes, sir.
And you understand what it is the state said you did, when, where, and how they alleged that you did it.
Yes, sir.
And you understand the possible penalty for that offense.
Yes, sir.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, the page 2, excuse me, on page 2, about 3/4 of the way down, there are a couple of sentences that are printed in bold and underlined. Those read as follows. Defendant will enter a plea of guilty to the indictment. State and defense jointly recommend 6 months incarceration consecutive to the sentence imposed in case number 23CR20. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is not up to the parties, it's up to the court. So even though the parties are agreeing to a specific recommendation, the court is not required to follow that. So if you plead guilty, once I've heard all the information, if I decide that's not the appropriate sentence, I could sentence you to as much as 18 months, fine you $5,000. Do you understand that?
Yes, Your Honor.
Now, Mr. excuse me. Mr. Horner, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Right, now you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel, and Mr. Armitrout was appointed to represent you. Now, he wasn't appointed simply to work the case out, but to provide any defense that might be available to you under the law that you like him to provide. So, if you decide that you do not want to plead guilty in this case, he'll continue to represent you and defend you, including a trial, if that is what you want. You understand that?
Yes, sir.
Now, under the Constitution, the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented. They'd be instructed on the law by the judge. And then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Right now, under the Constitution, Mr. Harner, you have a right to confront witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues court orders called a subpoena, and that forces those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Harner, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's your decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one is even allowed to comment about it except in one situation, and that is if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right? Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to show that you're not guilty of this offense. The burden is on the state. In fact, you're not even required to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state. Prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now originally, well, you actually haven't entered a plea in this case yet. So under the law, it is possible, or you could enter a not guilty plea to this offense. And a not guilty plea would deny the allegation in the indictment, deny you committed any crime, excuse me, and exercise all the rights that I just described. Now, if you plead guilty to the offense, that's the opposite of the not guilty plea. A guilty plea admits the allegations in the indictment, admits that it's a crime, that you committed the crime, and that plea waives, gives up all the rights that I just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty, waives, gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you and cross-examine through your attorney, waives, gives up the right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. Wage gives up your privilege against self-incrimination because you're saying you're guilty, that's what you define you guilty. And wage gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court, which is what's likely to happen today. And it wage gives up any right to file an appeal that you think you may have had for any alleged violations of your rights up until today. Now, if you are sentenced to the maximum sentence or under other certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Horner?
Yes, sir.
Now, do you have any questions about the charge, the possible penalties?
No, sir.
Do you understand it?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
Do you understand it?
Yes, sir.
And again, you understand the recommendation on the sentencing is not binding on the court.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty and what it means, what will happen if you enter that plea here today?
No, sir.
Do you understand that?
Yes, sir.
Now, I didn't tell you this originally, but if you do need to talk with your attorney privately, I can let you and him go into what's called a breakout room on the screen. It'll be just the two of you in the screen, and the deputy will step out while you're doing that, and no one else will be able to see you or hear you. So do you have anything you need to talk with him about or any questions you would like to ask him before we go any further?
Yeah, actually I would.
All right? I'm going to create a breakout room here, and there will be a button that's going to pop up that says join breakout room, and you'll need to click on that, and then when you're done, you'll click leave the breakout session, and then you'll have to log back in. The deputy will step out of the room while that's taking place.
Okay, sir. Thank you.
You're welcome. All right, we're back on record. Now, Mr. Harner, do you have any questions about anything I've explained then here this morning?
No, Your Honor.
All right. And is there anything else you need to talk to your attorney about before we go any further?
No, sir.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the agreement that we've just gone over?
Yes, sir.
All right, then as to the charge, which alleges that on or about May 18, 2023 in Highland County, Ohio, you did recklessly fail to appear as required in Highland County Common Pleas Court case number 23 CR 0020 after having been released pursuant to ORC section 2937.29. The release was in connection with a charge of the commission of a felony, in violation of section 2937.99 of the Ohio Revised Code, the offense of failure to appear, a fourth-degree felony, carrying a possible prison term between 6 and 18 months and a fine of $5,000. How do you plead?
I plead guilty, Your Honor.
All right, thank you. Court finds then on this date in open court, defendant is advised of all of his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to criminal 11. Please accept and ordered filed. Defendant is found guilty of the offense as charged. Now, inasmuch as Mr. Harner was already previously convicted in the other case and was set for sentencing, I did receive a pre-sentence report on that and have reviewed that. The court will go ahead and proceed with sentencing. All right, Mr. King, on behalf of the state.
Only way to obtain the plea agreement, Your Honor.
In case 23 CR 20, there was an agreement to pay restitution. Is there a restitution due in either of those offenses?
No restitution, Your Honor.
All right. Ben, we need jail time. All right, Mr. Armentrout, on behalf of the defendant.
Recommended sentence by the state of Ohio, which I think was 18 months on the earlier case and 6 months on the new one. I don't think it's a stretch for the court to imagine that when he absconded on the first charge, it's drug related. No recommended treatment at this point in this case, but on the figures up here, Judge, you can see that he owned responsibility for this immediately. I mean, he was just indicted, I think, at the last grand jury this month, and he's already accepted responsibility for using the ranked action. So we'd ask the court to impose the recommended sentence.
He's actually indicted on June the 6th. But all right. Mr. Yeah, okay. That's why I thought that's what you meant. All right, Mr. Harner, anything you'd like to say?
I just had that monkey on my back, Your Honor, and I couldn't shake him, and I'm going to use this time to better myself and get rid of this addiction once and for all. There wasn't nothing against not wanting to, come forward and deal with my consequences. It was just I couldn't shake the urge and I want to go get high, Your Honor.
How did you get taken into custody in Claremont County? Were you arrested or did you turn yourself in?
Clayton County got me at a friend's house.
Oh, okay. All right. Well, looking at the pre-sentence report, you have quite a history, Mr. Harner, most of it misdemeanors, but looks like most recently in March of this year you were convicted in Dayton Municipal Court on falsification and put on probation. January of this year, probation in Hillsborough Municipal Court for theft and disorderly conduct. 2019, an assault in Brown County. Failure to comply in Clinton County in 2017. You originally received 2 years of community control in the STAR program and were found guilty of a PV on April the 9th of 18 and sentenced to 12 months in prison at that time. Fishing without a license. I don't know why they bothered to put that on there. I don't believe that's a fourth-degree misdemeanor, but it is. Depositing a pop can. I don't know what that is. That's interesting. I've never seen that before. I have no clue what that means. But there's a lot of driving offenses throughout 2016, 17. So, you have had a number of opportunities to try to deal with this addiction, and you haven't done it. And so that's unfortunate. But it's the judgment and order of the court then that in the case number 23 CR 20 on count 1, that you be sentenced to a term of 9 months, and on count 4 that you be sentenced to a term of 9 months. Those sentences are ordered to be served consecutively to each other for a total of 18 months. And there is no restitution. In case number 23 CR 108, it's the order of the court that you be sentenced to a term of 9 months, and that that sentence also run consecutively to the sentences in the other case. The court finds that these offenses were committed as part of one or more series of conduct and misconduct, and that one single sentence for the offenses would not adequately reflect the seriousness of the crime, and the sentences that are being imposed are not disproportionate to the harm caused, being a mid-range sentence on each of the offenses. It is also ordered, or the court also finds that because of your criminal history and the commission of these various offenses, along with your extensive misdemeanor record and your previous felony conviction, that is necessary to protect the public. And finally, the 23 CR 108 offense was committed while you were released on bond in 23 CR 20 awaiting disposition. Now, with regard to credit, the court, according to the sheriff, you've been incarcerated 7 days here since you were returned from Claremont County, and that gives you a total of your previous 1 day or 16 day, 1 day of incarceration, and I'm sorry, yeah, there was 1 day in March and then 15 days in January. So that is 23. So you'll be given 23 days of jail time credit. All of that goes on 23 CR 20. There are no days of jail time credit in the new case because it's all being credited to the previous case. Now, upon completion of the sentence, it is possible that the adult parole authority may choose to put you under post-release control for a period of up to 2 years, which means that you'll be supervised on the terms they set by a parole officer, and if they determine during that period of time that you have failed to comply with those conditions, they can return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term. So that in this case would be 13 and a half months. Your total prison term is 27 months. However, if you commit a new felony while under post-release control, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. It's also ordered that you pay the court costs for which judgments, granted, and execution is ordered. If you fail to do that, the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, the court could permit you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded back to custody, Mr. Harner. Deputy, the court has been in communication with Claremont County, and they would ask, and we'd notify them that he would be available after this morning. So if they come to get him before you scheduled to transport him, I told them if they didn't get him by the end of next week, that you guys would go ahead and transport him to CRC. But if they come and get him before that, then they said they would transport him because of my understanding there's going to be a jail term imposed in that case as well, or prison term. Okay. So we'll send you an entry to that effect here later this morning.
Okay, thank you.
Thank you. If you could get us Mr. Hill, please. All right, it's case number 23 CR082, State of Ohio versus Donald Hill and Donald Lee Hill. You're Donald Lee Hill, appearing there from the jail?
Yes, sir.
All right, this hearing is being conducted by Zoom. Mr. Hill's attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. Mr. King, before we go on, as a victim, alleged victim of these offenses, or victims, I'm not sure how many there are, been notified of the time, place, purpose of this hearing, and the right to be heard.
Yes, sir, Your Honor. She's monitoring this hearing on the screen marked victim witness.
Okay, thank you. All right. Now, Mr. Armentrout, you indicated you would like to consult with Mr. Hill before we go on.
Yes, Your Honor.
All right, so what I'm going to do, Mr. Hill, is put you and Mr. Armentrout in what's called a breakout room on the computer, and there'll be a button that'll pop up. It'll say join breakout session, and you click on that, and then Mr. Armentrout and you will be the only one that'll be able to see or hear each other, and the deputy will step out of the room while that is going on, so that you can talk with him in private. All right, I'm having a little trouble here for some reason. Now, let me clear this and start over. On the leave the meeting and then have to be readmitted into the session. All right, we're back on record. Mr. Hill and Mr. Armentrout have returned from their breakout session. Mr. Hill is charged in a 5-count indictment with 5 counts of sexual battery, all third-degree felonies. The matter was scheduled today for a plea hearing, and I have been presented with a plea of guilty form. So are we going forward on this, Mr. Armentrout?
Yes, sir.
All right. You might need to turn up your volume a little bit. I'm having trouble hearing you.
Hear me now?
Yeah. Yeah, I'll turn mine up to maximum. I was about 90, so that might help a little bit. All right. So, Mr. Hill, I've been presented with this plea of guilty form, which indicates you're going to plead guilty to counts 1 and 2 of the indictment. Now, I'm going to hold that up to the camera on my computer. It has your name and case number, and it says plea of guilty, and it lists those 2 counts. You see that?
Yes, sir.
And you recognize that form?
Yes, sir.
On page 3 of this agreement, about halfway down the page, there's a sentence that reads, "I entered this plea voluntarily," and immediately below that appears to me to be the signature Donald L. Hill. And I'm going to hold that up to the camera and ask you if that is your signature there that I'm looking at on this form.
Yes, sir.
And when did you sign this agreement, Mr. Hill?
I believe it was Tuesday.
All right. When you signed this document, did you understand that it's an agreement to plead guilty, which means there won't be a trial, and the next step in this case will be a sentencing hearing?
Yes, sir.
And did you have your attorney explain everything to you and answer any questions you have and go over this with you before you signed it?
Yes, sir.
And do you feel that you had enough time to fully consider the matter before you signed the agreement?
Yes, sir.
Do you feel that you were rushed or pressured in any way into doing this?
No, sir.
And since it's been about 3 days since you signed it, is this still what you want to do today?
Yes, sir.
And now, are you entering into this agreement to plead guilty today voluntarily?
Yes, sir.
All right, now on page 1, as I indicated, it says you're going to withdraw your not guilty plea and plead guilty to counts 1 and 2. Both of those are sexual battery under 2907.03A5 of the Higher Revised Code. Both are third-degree felonies. Further states that you understand that the penalty for that offense, each of those, could be a minimum of 12 months or a maximum of 60 months, and there are certain levels in between that. There could also be a fine of $10,000. And if the maximum was imposed on each count, that could be a maximum of 120 months or 10 years and a maximum fine of $20,000. Do you understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction?
No, sir.
And are you currently on community control, probation, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you're sentenced to prison for this offense or offenses, once you complete the prison term imposed, it is mandatory that you be put under what's called 5 years of post-release control supervision, which means you'll be supervised by a parole officer under terms set by the parole authority, and if during that period of time they determine that you have failed to comply, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case has imposed, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now, under the law, a prison term is not mandatory for these offenses. And so what that means is that you could get what's called community control or probation. And that means that you would be put under supervision of the probation department for a period of up to 5 years under terms set by the court. If during that period of time the probation department felt that you were non-compliant, they would have a written notice of that filed with the court, give you a copy. There would be a hearing. You would be entitled to have an attorney, and if the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control, sentence you to 120 months, and fine you $20,000. Do you understand that?
Yes, sir.
Now, another consequence of this offense, if convicted, is that you would be designated as a Tier 3 child or sex offender, child victim offender registrant, which means you'd be required to register as a sex offender for the rest of your life with verification every 90 days. And failure to do that could result in criminal prosecution for a felony. You understand that?
Yes, sir.
All right. Now, the two charges we're talking about here, count 1 alleges that on or about the period of November 8, 2010, continuing through November 7, 2013, in Highland County, Ohio, you did engage in sexual conduct with V, stands for victim, not the spouse of the said Donna Lee Hill, the said Donna Lee Hill being the step-parent of V, in violation of Section 2907.03A5 of the Higher Revised Code. Count 2 reads the same. And I assume, Mr. King, that you are talking about two different incidences during that period of time.
Correct, Your Honor.
All right. And that's understood, Mr. Armentrout?
It is, Your Honor.
All right. Now, each of those are the offense of sexual battery with the penalty I just described earlier of 12 to 60 months in prison, a fine of $10,000, plus the requirement to register as a sex offender for your life. Do you understand the nature of these charges, what the state said you did, when, where, and how they allege that you did it?
Yes, sir.
Do you understand the possible penalty?
Yes, sir.
Have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs there at the jail?
Just some meds through the psychiatrist.
And is any of that medication interfering with your ability to talk with your attorney, to understand what I'm telling you, to express your thoughts accurately?
I don't think so.
Okay. Well, if there's anything you're not certain of, you have any questions, you just tell me and I'll answer them, or if you need to talk to Mr. Armentrout further, you can do that, okay? Has anyone threatened you to make you plead guilty here today, Mr. Hill?
No.
Now, on page 2 of this agreement, toward the bottom, there's several sentences that are printed in bold and underlined. I'm going to read those at this time. Defendant shall enter a plea of guilty to count 1 and count 2. State will dismiss remaining counts. State and defense jointly recommend 36 months incarceration on count 1, consecutive to 42 months incarceration on count 2. Defendant shall be a Tier 3 registered sex offender. So the recommendation is for 78 months total prison term, which is 6.5 years. Now, is that your understanding of the agreement, Mr. Hill?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Mr. Hill, the matter of sentencing is up to the judge, not to the parties. And so even though there's an agreement as to what the sentence should be, the court is not required to follow that agreement. I can, after considering all the information that's submitted, determine that that's not the correct sentence, and I could impose a different sentence anywhere from 12 months as a minimum up to 120 months as a maximum. Fine you $20,000. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
All right, now you have constitutional rights you must understand before I can accept your plea here this morning, Mr. Hill. First, you have a right to counsel, and Mr. Armentrout was appointed to represent you. Now, that appointment isn't simply to work the case out. It's to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide that you do not want to do this, that you don't want to plead guilty, that you would rather defend against the charges, he'll continue to represent you to provide that defense, including a trial, if that is what you want. You understand that?
Yes, sir.
All right, now under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those people were selected, the evidence would be presented, then they would be instructed on the law, and then that jury would decide by unanimous verdict, meaning they all 12 would have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, and then you would have what's called a court or bench trial, meaning the judge would be the one to hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Hill, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court and testify in front of you and your attorney and anyone else that's present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Hill, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court will issue a court order. It's called a subpoena, and that forces people that are named in the subpoena to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to trial to testify against you. Do you understand that?
Yes, sir.
Now, Mr. Hill, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify in this matter cannot be used against you at any time by anyone in the proceedings. And in fact, no one can even comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now under the Constitution, Mr. Hill, you are presumed innocent of these charges until proven guilty by proof beyond a reasonable doubt by the state of Ohio on every essential element of each of the offenses. So the burden of proof isn't on you to try to prove you're not guilty, simply because you've been charged. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, Mr. Hill. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've explained to you. Now, if you change your plea from not guilty to guilty, that is a complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, and that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront the witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination. Excuse me. Because if you say you're guilty, that's what you find you guilty. It would waive or give up your privilege against your presumption of innocence. Because if you say you're guilty, then the state doesn't have to prove you're guilty. Now, a plea of guilty also waives or gives up any right to file an appeal that you think you could have had up until this point in the proceeding. Now, if you were to be sentenced to the maximum sentence or under other certain circumstances, you could file an appeal. That appeal would have to be filed within 30 days of the sentencing entry being filed. And finally, it would subject you to being sentenced immediately by the court, which is likely what would happen if you plead guilty here today. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Hill?
Yes, sir.
Now, do you have any questions about the charges or the possible penalties?
No, sir.
You understand them?
I think so, sir.
Well, you think so. You understand what the possible prison term is of 12 to 60 months on each case consecutive? Or up to 20, meaning 12 to 120 months. You understand that?
Yes, sir.
And you understand you could be fined $10,000 on each count?
Yes, sir.
And you understand that you will have to be designated as a sex offender registrant for the rest of your life once you get out of prison?
Yes, sir.
Okay. So you do understand the penalties then?
Yes, sir.
All right. Now, do you have any questions about the plea agreement?
No, sir.
And you understand?
Yes, sir.
And you understand that the sentencing recommendation is not binding on the court, so, I could sentence you to the 78 months, or I could sentence you to less, or I could sentence you to as much as 120 months. You understand that?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand that? Those?
Yes, sir.
Okay. You have any questions about the plea of guilty, what it means, what will happen if you enter pleas of guilty to these two charges today?
No, sir.
You understand?
Yes, sir.
Now, do you need to speak to Mr. Armentrout any further about anything before we go on?
No, sir.
You have any questions about anything that I've explained to you here this morning?
No, sir.
Then is it your voluntary decision, Mr. Hill, to withdraw your not guilty plea and plead guilty to counts 1 and 2 pursuant to the terms of the agreement that we've just gone over?
Yes, sir.
All right, then as to count 1, which alleges that on or about the period of November 8, 2010, continuing through November 7, 2013 in Highland County, Ohio, you did engage in sexual conduct with V, not the spouse of the said Donald Lee Hill, the said Donald Lee Hill being the step-parent of V, in violation of Section 2907.03A5 of the Ohio Revised Code, charge of sexual battery, a third-degree felony, carrying a possible prison term of between 12 and 60 months in increments provided by law, a fine of $10,000, and a duty to register as a Tier 3 sex offender for the rest of your life. How do you plead?
Guilty.
As count 2, which is the same language, but represents a different incident, but otherwise the same offense, the same penalties, and a requirement to register. How do you plead?
Guilty.
Right. All right, the court finds that on this day in open court, defendant was advised of all of his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal 11. The plea is accepted and ordered filed. The defendant is found guilty of counts 1 and 2 as set forth in a plea agreement. Counts 3 to 5 are dismissed. Now, due to the nature of the offenses and the stipulated agreement between the parties as to a prison sentence, the court is not going to order a pre-sentence report, and I will proceed with sentencing forthwith. All right, Mr. King, on behalf of the state.
Thank you, Your Honor. The state would ask the court follow the joint recommendation. The victim has approved of this agreement, and the victim would like to make a statement at this time, Your Honor.
All right. If you would identify yourself for the record, please, and make your statement.
Tori Goldman.
All right, go ahead.
I just wanted to start by saying you were the one who cut my cord when I was born. I grew each day watching your footsteps as you guided me through life. I trusted you was the parent that was more easy to talk to. Then came confusion for me as a teenager and weird feelings that I should have never had to experience because you were supposed to be my dad. Well, I want you to know it was never okay. It made me feel nasty and like it was my fault. Well, I've grown a lot since age 22. I want you to know this has affected my life as a wife and as a parent. I have unwanted thoughts of my husband because he now has the label of a stepdad. If you want to know what made me come forward, it started after I got married. That was a trigger for me because now my kids have a stepdad. When I would leave at night to go put my client to bed, I would have thought that maybe he would do something to my daughter because that's what my stepdad did to me. But I know he isn't that kind of man. And the thoughts were uncontrollable. I started getting depressed, and my anxiety started to get out of hand. I knew I couldn't keep living like that, so I contacted the proper authorities and got the help that I needed. Then I started seeking counseling to get even further help that I needed. And I've had a wonderful support system, and I feel so much better now that I've let it all out. What really bothers me is during the investigation, how you openly talked about me at age 16. That made me sick. Knowing you haven't changed and also makes me feel like you would do this to someone else's child. I went forward for justice for myself and to protect my family and to make it harder for you to offend someone else. I don't ever want you around me or my family ever again.
All right, thank you. Anything else from the state?
No, Your Honor.
Mr. Armentrout?
Now we're asking the court to follow the recommended sentence, which was approved by the state of Ohio and by this unfortunate young lady. I've had many conversations with Donald about this, and while you explore defenses, he's always been open with me. I think he's going to try and make a short statement. Donald gets tongue-tied fairly easily, but I can tell you from speaking with him, he's owned it. He's remorseful. He knows it was wrong. I'm not casting any aspersions on this young lady whatsoever. He's admitted to it. He's pled guilty. There is no excuse. I think he does have a couple words he'd like to address the victim. And we hope the court will follow the resolution when we work this case out. That's all.
Okay. Mr. Hill, anything you would like to say?
I just want to say to Ms. Goldman, I'm very sorry. I hope that within time she can find time in order to forgive me.
All right. Well, before I pronounce the sentence, I'm going to inform you of your duties to register as a sex offender. I do have this form before me that indicates that you signed this, I believe, on August the 8th. I'm going to hold that up to the camera and ask you if you recognize that form and your signature there at the bottom.
Yes, sir.
All right. Now, under the law, you are hereby designated as a Tier 3 sex offender child victim registrant, which means you'll be required to register for the rest of your life as a sex offender with periodic verification. First of all, you must register with the sheriff of the county in which you establish a residency not later than 3 days after you go into that county, or if you're going to stay there temporarily for more than 3 days. You're also required to register in person with the sheriff of any county if you establish a place of education, like going to any kind of job training, educational programming, college, etc., immediately. If you are employed in a county other than where you're living, then you must register there if you work in that county for 3 days in a row or more, or a total of 14 days in any one calendar year. So you could be required to register in as many as 3 counties: where you're living, where you are going to a place of education or training, and where you are working. And for purposes of this law, community service or volunteer work also includes employment, is defined as employment. If you are going to be absent from your residential location for 7 days or more, a vacation, go to visit family, hospitalized or something like that, you must notify the sheriff of that and how long it is expected that you will be away from your residence, and the information about the location and of where you will be living or staying during that absence. Now, in the event that you are you move to another state, or you work in another state, or you go to a place of education in another state, you will have to register with the sheriff or whatever public official is charged with the responsibility under the law of that state for maintaining sex offender registers. If you are going to change your residence, employment, or place of education, you must provide written notice of that to the sheriff of the counties where you are registered. If it is in the county where you reside, you must notify them of and the sheriff of the county in which you're going to move into at least 20 days before you do that. If it's a place of education, you must do that as well. Now, 20 days in advance. For employment, you have up to 3 days after you move or change, because you can work in any county for 3 days, up to 3 days in a row without registering. Now, in the event that you should not have a fixed address, You shall include a detailed description of the place or places you'll be staying, and no later than the first business day immediately following that date that you do obtain a fixed address, you must register that with the sheriff. Now, under federal law, you're required to report any plans for international travel to your registering authority at least 21 days before the travel, and if that you fail to do that, you could be subject to both federal and state prosecution for a felony. If you have any change in your vehicle information, any email addresses, internet identifiers, or telephone numbers that you are using or that register to you, you must also provide changes or notice of those changes with the sheriff or sheriffs of the counties in which you're registered. Now, you'll be required to verify this information in each of the counties at least 90 days, every 90 days in person. It can't be by email or phone call or Zoom or anything else. It has to be in person. And you cannot do that any earlier than 10 days before the verification date. So your verification date will be every 90 days. You could re-verify 80 days, after 80 days, 10 days before that. So between the 80th and 90th day is when you can do that. And at this point, your residence is in Highland County, so if you were released back to Highland County, then the address of the sheriff's office is there at 130 Homestead Drive in Hillsborough. If you fail to comply with any of these requirements to register, verify periodically, provide notices of changes in any of the information, residence, employment, or place of education, you would be subject to criminal prosecution under Chapter 2950 of the Ohio Revised Code, which is a felony. And for the record, Mr. Hills acknowledged that he had read these rights previously and has signed it, so I'm going to sign it now. The 11th, right?
Yes.
All right. Now, before I go ahead and announce the sentences, or anything further from the state?
No, Your Honor.
Anything further from this defense?
No, sir.
All right. Well, Mr. Hill, the abuse of the relationship of parent-child or step-parent, stepchild is particularly abhorrent because of the position of trust and what Ms. Bowman has just explained to the court and the consequences and effect it's had upon her. She's done quite a bit in terms of dealing with it and trying to get on with her life, and I know it's, I'm sure that it's difficult. I can't say I know it, but I can say that I'm sure that it's difficult because from my experience in these years of seeing this, that, I've seen many, many people that have been terribly impacted, some of them permanently scarred. It's not something that will ever go away, but I would commend you, Ms. Bolden, for what you have done in dealing with this, and I hope that you'll continue to be able to improve and lead a good and productive life as an individual and as a parent. Given the fact that the parties have agreed to a specific sentence, Mr. Hill did take responsibility for that. The court will follow the agreement recommended sentence. So it is the order of the court that Mr. Hill, you be sentenced to a term of 36 months of incarceration at the Correctional Reception Center at Orion, Ohio on count 1, and that you be sentenced to a period of 42 months of incarceration at the same facility on count 2. It is ordered that those sentences be served consecutively to each other for a total of 78 months. And according to the sheriff, as of today, you were arrested on May the 4th, is that correct?
Yes, sir.
All right, so as of today, that is 99 days of jail time credit. Now, upon completion of the prison term, it is possible that not possible, it is mandatory that you be placed under post-release control, supervision, by the Adult Parole Authority for a period of 5 full years. And that means you'll be supervised by a parole officer under the terms they set, because the court doesn't have anything to do with that. If during that period of time the parole authority feels that you have failed to comply, then they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum, in this case, of 39 months for more than one violation. However, if you commit a new felony while under post-release control, then in addition, whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing this new offense while under post-release control in this case to an additional period of 1 year, or whatever time would be left on that 5 years of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you fail to do that, then the court could require you to do community service in this county once you complete your prison term, not while in prison, but once you complete it. And you would be given credit for each hour you worked in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, I don't recall if the court explained the reason for consecutive sentence.
You're right, I did not, thank you. The court finds that the recommendation for consecutive sentences is part of the plea agreement. The court will further find that the nature of that they were committed as part of a series of misconduct over a period of time, and that one single prison term will not adequately reflect the seriousness of the offenses, and that the amount of prison being imposed in each case is not disproportionate to the harm caused, and that the defendant's previous record, I see that he has had previous conviction for a felony in another state, as well as other offenses, OVI, as well as a vehicular homicide. And so, I don't know, is that vehicular homicide or vehicular assault? I don't want to misstate the record. Vehicular homicide. And so, therefore, the consecutive sentences are necessary for the protection of the public. All right, anything further?
No, Your Honor.
All right, you're remanded to custody, Mr. Hill, to be conveyed to CRC. Thank you.